Hi, and welcome to the Law Simplified. I'm Shaveen Bandadnayak. A question I often get posed by those of you who watch these YouTube videos, as well as my masterclass and fast track students from around the world, is how am I marked? Now, this, as simple as it may sound, is quite a loaded question because the determination of how you are marked in terms of your law examination or assignment submission depends on a number of factors. It might depend on the subject that you are sitting for this exam or assignment submission on. It might depend on the country or the jurisdiction that you're studying law in. It might be as granular as the professor or the university that you're enrolled with as well. But that being said, over the past several years, I've had the privilege and opportunity of not only being able to hone the techniques of students that have gone on to become first class, even upper second students in terms of their degree, as well as going into the profession as solicitors and barristers, some of whom have gone into government office as well, such as members of parliament and ministers. But on the other hand, I've also had the opportunity to pick the brains, so to speak, of examiners and assessors who've had countless decades of experience around the world. As such, the following is a composite of what I have gathered and learnt over the years in terms of how to articulate the marking process, so to speak, of examiners. Now, mind you, a bit of a caveat and a warning at the very outset. This you would not find from, let's say, the rubric of a university in particular. Rather, this is what I have encountered and from experience understood what examiners are looking for in terms of the articulation, the arguments, or the substance. So bear in mind that this is a broad stroke overview of how an examination is marked, how examiners go about looking at responses or submissions by students, and it by no means reflects what any particular university employs in terms of marking or assessing their students. That being said, if you enjoy the content that I make on this very YouTube channel, as well as the different platforms that the Law Simplified is disseminated on, make sure you give a thumbs up and do subscribe to the Law Simplified. Now, on a number of occasions, I have mentioned in passing certain aspects of a law degree and more in particular the examination or assignment submissions that you need to look out for in order to take it from a pass to that of an ace. But specifically speaking, in terms of any examination or assignment submission, regardless of the university that you're enrolled in, the format in which you're assessed falls into three categories. On the one hand, they're going to look at your substance, your knowledge, whether you know the law. On the other hand, they're going to look at whether you are able to substantiate the knowledge you have with case law, with statute, with black letter law, so to speak. And thirdly, are you able to show your personality? Are you able to argue as well as to show the examiner how you're thinking? Now, in relation to this third aspect, I've recently done a video which you can check out through the links in the description or by clicking on the card that will appear on the top right there. But more or less, the most important thing to recognize is that not all three of these circumstances of the areas that an examiner looks for is created equally. Now, the way in which I break this down and how I train my fast track and masterclass students is to look at any question being marked out of 25. And if you take any particular question being marked out of 25, consider the fact that your knowledge or the substance is marked at 8, the substantiation or the case law, as well as any articles or any statutes that might be relevant, marked at another 8. But your arguments and personality being marked at a 9, cumulatively making up for the 25 marks. Most of the time, what takes place is that students tend to focus heavily on the knowledge component and also somewhat on the substantiation component or the case law and statute component, but completely neglect showing off who they are and how you think. So because of this, You will have students, for example, who are very knowledgeable in the law that have scored heavily in that first component, essentially the 8 marks out of 25, but failed to do so in the second and third, especially the third. This in turn means that you'll have a knowledgeable student who ends up with an overall grade or an overall mark of about 50 out of 100 at best. More often than not, even more so than trying to equate yourself or trying to compartmentalize yourself into doing well in one of these 3 or 2 of the 3, it is best to be, and I hate to use this word as such, average in all 3. In other words, if you are somewhat knowledgeable in the law, you are aware of the relevant case law and statute, and you have a great personality and a great way of arguing, even substantially getting part of all of this, essentially a 4 out of 8 in the substance, a 4 out of 8 in the substantiation, and something like a 5 out of 9 in terms of the arguments, you'd still essentially be able to cross over a 12 or a 13 out of 25, which counts for about half of what the grade would be. As such, even as a worst case scenario, you're looking at a 50 or a 55. Now, that being said, I have to again emphasize on the fact that this is a composite based on my experience and interactions with both students who have achieved first class law degrees as well as examiners who've had countless decades of experience marking examinations as well as assignment submissions. So you need to understand that this is one way of gathering insight into how exactly you should write examination questions. But since this was a question I get posed quite often, and I thought it's best to put it out there in the context of a quantifiable technique that you can implement. That being said, until the next time that we meet, have fun, stay safe, and as always, obey the law.